Good morning. My name is Sam Beighton. I am a partner at Gowling WLG, and I will be talking this morning about the new vertical regime that we have within the UK. Hopefully, this is what you signed up for and expected. If it's not, obviously now is the time to drop off and save yourself an hour. If it is, then hopefully there will be things within this presentation that are of interest and of note. Just to kick off then, in terms of what could be of interest and of note, as a starting point, what I'd like to do this morning is just outline the function of the new block exemption order, to think a little bit about what we have now in terms of the old and the new regimes. We're familiar with the old, we're welcoming in the new, but what are the key similarities between these different regimes? I then want to touch on areas of evolution, and in particular focusing upon exclusive distribution and selective distribution. Now, these were models that we're well familiar with, but there are some areas where these have evolved in the context of the new UK order. There's another aspect to flag, which is an obligation to provide information to the CMA arising under the new order. And I just want to touch briefly upon the transitional provision before moving on to questions. And I'm conscious this obviously is a new area. I think there will be lots of questions for us as practitioners. There are questions around how this will play out in practice. So questions, it's on me then to leave time to make sure we have questions and time to deal with those. But without further ado, what I would like to start off with is perhaps a little housekeeping before we get into the substance of the session. And on the slide before you, you will see, I suppose, a visual representation of our new block exemption order. And ambitiously, when I set about preparing for this session, I thought we could perhaps cover all the bit of the iceberg that's above the water there. I think having stood back from this and seen how wide this is and how it applies, I think realistically, we will probably be covering the little red bit circled there. We will look at that, we will go into that in some detail. But I think it's important to note, this is the tip of the iceberg. There are lots of other issues and areas arising around block exemption order, which I'm sure you'll come across in your businesses. And obviously, we are very happy to help with those as and when they arise. But this session, unfortunately, in the time available, it cannot cover the full breadth of the block exemption order. So what I won't be covering, and again, this gives you an opportunity to log off if these were particular points of interest for you. What I won't be covering are wide retail parity obligations, which have now moved to being a hardcore restriction under the new order. I won't be touching upon agency. I think we could probably have a session in itself upon agency. So I won't be looking at agency, whether that's genuine, non-genuine, or the dual role agency model that we see emerging under the new order. And I also won't be touching upon resale price maintenance or fulfillment contracts. So those aspects I won't be covering today, unfortunately. I think another point of housekeeping as well is just to flag that the area being what it is, I'm afraid that there will be technical legal concepts that are discussed. I have tried to make these as accessible as possible. It's not in my gift to strip them out of the session entirely. Hopefully these all make sense, but if there are points which don't, then I'm very happy to pick those up after the session if that would be helpful. So just having a quick look at numbers. We've got about 6 people still online following those housekeeping tips. So hopefully the remainder of the session will be useful for those who are still with us. Jumping in then to the substance of this and thinking about the new order in terms of its function. So what we have, as we are familiar in terms of a regime, is a regime that's applicable to vertical arrangements. And the new order does exactly that. It applies to vertical arrangements between different undertakings, which are primarily at different levels of the supply chain. And those arrangements cover how the parties purchase and sell products and services. What the block exemption does is it creates an automatic exemption from Section 2 of the Competition Act, the Chapter 1 prohibition. And this creates a safe harbour for arrangements that satisfy the criteria of the order. Helpfully for businesses, this safe harbour principle affords them greater certainty, and there's efficiency of operation as well. If you know you have a safe harbour that's available, that's certainly something to aim for. And I'm conscious the CMA, when it was considering where the UK should go in terms of a vertical regime, the feedback, the very clear feedback from business was the safe harbour concept works well, and it should be continued going forwards post-Brexit. So I think against that background, what we often see where we have clients who are considering entering into vertical arrangements is they'll often seek to draft their agreement, their arrangement, to benefit from the block exemptions. They will go through, they will look at the applicable criteria, and they will craft their arrangement around those. I think a really important starting point before you jump into block exemptions, though, is to actually think about the arrangements at hand. First question to ask is, would it actually be caught by the Chapter 1 prohibition? And for many things, they will be. But there are some arrangements that perhaps wouldn't be because the parties' market shares are perhaps low enough they could benefit from de minimis doctrine, for example. If you don't actually find yourself with a situation where the arrangement is caught by the prohibition, then obviously the benefit of the block exemption isn't legally required. You don't need to have the exemption from something that doesn't apply. And if that is the case, that may give greater commercial freedom. So when you're thinking about structuring the arrangement, not having to consider the application of Chapter 1 rather than jumping straight into the block exemption, assuming it applies, that may then give greater commercial freedom to the structuring of that arrangement. But let's assume that we have an arrangement that is caught by the Chapter 1 prohibition. So if it is the case that the block exemption is available, then, as I mentioned previously, there will be the automatic exemption from that prohibition. If the arrangement falls outside the block exemption for any reason, the question then is whether or not individual exemption is a possibility for the parties. And when we're thinking about individual exemption, we're touching here upon Section 9 of the Competition Act. And in this context, it's for the parties to evidence the 4 cumulative conditions that are listed within Section 9. And in summary, what the parties need to demonstrate, be capable of demonstrating, is that there are efficiencies that result from the arrangement, that consumers receive a fair share of these efficiencies, the restrictions in question, they're actually necessary for the achievement and attainment of these efficiencies, and the restrictions in question do not allow the opportunity for the parties to eliminate competition. And this is where the parties have the obligation to self-assess. This isn't something that the CMA is going to do for the parties, and as you are aware, this is an issue for self-assessment. We do have the draft guidance accompanying the new order that has been issued by the CMA. We are awaiting the final version of that, but nevertheless, the draft, I think, indicates a direction of travel, enabling parties to consider and self-assess whether they do have arrangements that would fall outside of the block exemption. And we're also awaiting CMA guidance on sustainability agreements. That has been flagged by the CMA as a point it will develop. We don't have a timescale for that, but I think it's noteworthy that within the existing guidance for block exemption, there are references there to this future guidance on sustainability agreements. So there'll be other aspects in there which I think would lend support to the possible case individual exemption. So self-assessment required, but guidance is out there. And just by way of a timeline, I think this is worth flagging just a point of policy. We have here outlined the brief timeline of what we had before. So the vertical agreement block exemption regulation, which emanated from the EU, which entered into force on the 1st of June 2010. We fast forward 12 years. We have the new order entering into force in the UK. That replaces what became the retained block exemption. So post-Brexit, the existing EU regulation just rolled over into UK law. The new order fully replaces that. And in parallel, we have within the EU a new block exemption that entered into force on the 1st of June. Now, interestingly, the EU block exemption is due to expire in 2034. The new order in the UK is due to expire in just under 6 years' time now. And that was a very deliberate policy choice. When the CMA was recommending the new order to the Secretary of State, there was a lot of thought going into how markets may evolve, how technologies may develop, which may then mean further revisions are required to the applicable order in the short-ish term to ensure that this drives forward the interest of the UK economy. So as we will see going through the presentation, at present, we do have a broad alignment between the new order in the UK and the EU block exemption. However, it'll be really interesting to see in 6 years' time whether we still have that alignment or whether there is further divergence, taking into account the position and direction of travel within the UK economy and the role of the block exemption in the UK in furthering the interest of the UK economy. So following that background, what I want to touch on now is a bit of a compare and contrast between the old and the new regimes that applied in the UK, and just touching upon some of the key similarities from that. I think the first thing to flag is that the new order reads very differently to the old retained block exemption that we inherited post-Brexit. Anyone who's had the opportunity to read the new order, it's a very different look and feel to it. It's not immediately recognisable as what we would call a block exemption. It has been sort of recrafted, redrafted, and as I say, has a very, very different look and feel. However, once you get past that initial kind of reaction to something that looks so different, what you find is that many of the concepts actually remain the same. And as I mentioned previously, there are also very clear similarities between the new order we have in the UK and the new EU block exemption applying on obviously the European Union member states. So very, very clear similarities. There's a lot that's actually staying the same within this, even though this is obviously a new regime coming into force. So one of the key similarities is the parties. Now, the new order primarily applies to non-competitors, vertical agreement block exemption. However, where you have the block exemption, there is the possibility for this to apply to non-reciprocal arrangements between competitors. That's subject to certain conditions being satisfied. So it can apply to arrangements between competitors if the supplier is a manufacturer and a distributor, and the buyer is just a distributor, so they're competing at a downstream level. Equally, if the supplier is a multi-level service provider and the buyer is active at the retail level only, again, you just have the competition at the retail level. Those arrangements being non-reciprocal could still potentially benefit from the new order. And that is consistent with the position that we had under the old block exemption in the UK. What the new order does, it goes a little bit further. It expands the approach and allows the order to apply to situations where the supplier is perhaps a wholesaler and distributor, and the buyer is just a distributor, and where the supplier is an importer and a distributor, and the supplier is an importer and distributor, and the buyer is just a distributor. So again, you have competition only at the retail level. They are competitors, but there are these exemptions which allow the block exemption order to cover those scenarios where other conditions are also satisfied. This greater breadth of application, I think, is to be welcomed. I think under the previous regime, there were some grey areas where it wasn't quite clear based upon the definition of the supplier, whether or not the agreement could benefit from block exemption. So as I say, greater breadth of application, I think, is to be welcomed. It also is consistent and aligns with the approach under the new EU block exemption. Another familiar area in the context of vertical block exemptions is market shares. The new order in the UK, again, is based upon the satisfaction of certain market share thresholds. These have not moved, so these will be well familiar. We have initially the market share of the supplier is obviously 30%, and market share, by this reference, is the relevant market on which the supplier sells the contract products and services. Similarly, the market share of the buyer must not exceed 30%. And again, this is the relevant market upon which the buyer purchases the contract products or services. In terms of market definition, and this really is what underpins those shares, the CMA's guidance is going to be relevant in this context. It's relatively old guidance that the CMA has adopted from the Office of Fair Trading, but is expressly endorsed within the accompanying guidance to the new order. So that approach to market definition remains relevant. And when the parties are thinking about their shares, this is by reference to each party's corporate group. So it's one entity in the context of a wider corporate group. You're thinking about actually what are the activities of that entire corporate group rather than just the contracting entity. And where relevant, the shares should include the supplier's vertically integrated sales. So if the supplier is active within its own group, making sales downstream to parties acting as distributors, those need to be wrapped up in terms of its market shares. And shares to be calculated using ideally value data. So if there's third-party data considering market size, that's going to be really helpful. If that's not available, then the party substantiated estimates can be used in this context. And the shares are calculated by reference to the preceding calendar year. So we have the methodology outlined in the new order, which again is consistent with both what we had before in the UK and also the new vertical block exemption within the EU. So this kind of bedrock of how you go about assessing market shares, how you go about thinking about the application of the order, that hasn't changed. That remains consistent throughout. I think that, again, is a really, really helpful point. Hardcore restrictions. The new order may apply provided the arrangement does not include hardcore restrictions. Now, I haven't listed all of these out here. I've just picked out a few examples. So we have resale price maintenance, living on chestnut in terms of a hardcore restriction, and certain restrictions upon sales into territories and types of customer, and absolute bans on internet sales, all of which would be seen as hardcore restrictions. The hardcore list under the new order is a little bit different to what we had previously. And what we see, and we'll touch upon this later in the session, is that the new order is more permissive of different treatments of online and offline channels. So the quite rigid approach taken in the old block exemption and the accompanying guidance to online, offline has gone in this new order, which again is to be welcomed. And what we see with the hardcore list under the new UK order is, again, perhaps unsurprisingly, it's broadly consistent with the direction of travel in the context of the EU new block exemption as well. Excluded restrictions. Again, this is a concept that I think we will be well familiar with. And I've put here what I think is probably the classic excluded restriction under the vertical block exemption regime, and that is the non-compete obligation that exceeds 5 years. So I think everyone has come across that previously. The new order in the UK does not apply to severable excluded restrictions. So those are listed in the order, and the order will not benefit, will not apply, will not protect those in terms of the safe harbour concept. So if you have something that's a severable excluded restriction, the question then is, okay, it doesn't benefit from the order, but can it benefit from individual exemptions? So we go back to section 9, we think about the cumulative criteria. A lot of these types of restrictions, if they are outside the order, may well find themselves capable of individual exemption under section 9. So it's not something which is outright prohibited. I think what's quite interesting in the context of the new order, though, is it makes really clear that if an excluded restriction cannot be severed, then the entire agreement will lose the benefit of the block exemption order. And to my mind, that's the first time I've seen that articulated as clearly as that. I think it's something that you may find people then, when they're thinking about their drafting, they may want to put in some wording there just to make expressly clear that if they do have excluded restrictions in their agreement, that these are being identified and flagged as things that the parties intend to be severable. So that these are clearly severable, and therefore there are excluded restrictions that can be severed. The agreement should then benefit from the block exemption order absent those restrictions. So that's, I think, a point that we may see more emerging in the drafting as a matter of practice. The restrictions list, though, it doesn't really move the dial. It's consistent with what we had previously in the UK. And again, it's broadly consistent with the new block exemption regime within Europe. So again, we're seeing this running theme of, yes, it's a new regime, but actually there are a lot of things here that are building upon what we had previously. So the overall structure then, in the context of the new order, is it's available where the parties are not competitors or they are permitted competitors. The parties' market shares do not exceed 30%. The agreement does not include any hardcore restrictions or excluded restrictions that cannot be severed. As I mentioned previously, this overall structure, it looks familiar, it feels familiar, and it's broadly aligned with the new EU block exemption. So there's a lot of comfort around here in terms of this is an evolution rather than a revolution. We have things that look and feel familiar with some developments and nuances, but it's not starting again from scratch in terms of a brand new novel UK regime. So thinking then about areas of evolution, I think the first point to pick up on, and I think this is probably something which we have now as a consequence of where we are post-Brexit, but it's something that I think we can expect change in as well. So I think this is a point where we've already had some evolution. I think we can expect some further evolution around this particular issue. So the chapter on prohibition applies to arrangements that are implemented or intended to be implemented in the UK. Obviously, that is much more limited in scope than the application of Article 101 under the Treaty of Function of the European Union, so the old EU provisions that we had. What this means, though, is that as drafted, arrangements that are implemented outside of the UK would not be caught by the chapter on prohibition. And that's quite a big thing. And that's something which in the UK, we don't currently have a comparable doctrine of qualified effects as exists under EU law. So under EU law, you can have things that are implemented outside the EU, which have certain effects in the EU and are still caught, therefore, by EU competition law. We don't have something comparable under the chapter on prohibition at the moment. There is a proposal to revise the chapter on prohibition, and what this revision would do would extend its application to indeed cover certain arrangements that were implemented outside the UK if these gave rise to specific types of effect in the UK. So greater territoriality in terms of the reach of the prohibition from the UK to arrangements outside of the UK. I think there's a really big question here, which will become, I think, more important for businesses that are active in both the UK and the EU, is if this revision does take place, what does this then mean in terms of both the application of the chapter on prohibition and also the application of the block exemption order? Because that would then bring in certain restrictions that are taking place outside of the UK. If they have effects in the UK, that is likely to see them perhaps falling within the remit of the prohibition, and therefore we may need to think more about how the block exemption order would apply to those sorts of arrangements. So that's an area where obviously we are looking at the revision. We don't have a timescale for that yet, but if and when that does happen, we will, I think, have to see further changes in terms of the block exemption order and how this applies in practice. I think to frame the next couple of slides, it's probably helpful for me just to outline a couple of the core distribution models that we see considered within the new UK order. The first one, and you will be well familiar with this, is the basic model of exclusive distribution, whereby we have a supplier allocating geographic areas and or customer groups either to itself or to a distributor. And having allocated those areas or groups, what the supplier can then do is restrict active sales being made into those areas. The exclusive distribution, we're thinking about a degree of territorial protection in the context of the sale of contract goods or services. The other model just to pick up here is quantitative selective distribution that I will refer to as selective distribution. And in this context, we're thinking about a different model. A limited number of distributors are being selected. They're not allocated exclusive areas or customer groups, but they exist in a network. And those selected distributors, they cannot make active or passive sales to any unauthorized resellers in the area in which the network operates. So in the context of selective distribution, traditionally, we've been thinking about more brand protection or value protection rather than territorial protection. I mentioned in the preceding slide, active and passive sales. I think just to confirm what we mean in this context, So when we're thinking about active sales, we're thinking about the active targeting of customers. And the new order has expanded this ever so slightly, just to make clear that active sales would include things like using website language options that perhaps don't coincide with the allocated area, if you think about exclusive distribution, and also the use of different geographic domain names. So if you are using a .Wales domain name to make sales to customers based in Wales, then that is actively selling into Wales, as compared to, say, a .co.uk domain name, which is just a more general domain name, not actively targeting a specific customer base. When we're thinking about passive sales, we are thinking about responding to customer requests that are unsolicited. And what we have as a general wraparound is that the new order in the UK makes really clear that suppliers should not prevent distributors or their customers from effectively using the internet to make active or passive sales as they're permitted to do so. So we see, and we'll touch upon this, the internet being viewed still by competition authorities as a key space within which customers, consumers search for and obtain value when they are purchasing products. We're touching first, though, when we're thinking about evolution and what the order brings to us now on the issue of exclusive distribution. And what we see as is a step change from where we were before is that the new order permits a supplier to exclusively allocate more than one distributor to a geographical area or a customer group. So exclusive doesn't mean one anymore. Exclusive can mean more than one distributor. What this then means is where you have the allocation of an area to more than one distributor, that distributor in the area must be able to make active and passive sales in the area. So when they've been allocated an area, there's more than one of them, they must all be able to make active and passive sales in their allocated area. So just by way of an example, we have Territory 1, which is Bristol in England, and this has been exclusively allocated to 3 distributors. There they are, 1, 2, 3. And these 3 distributors must be able to make active and passive sales in Bristol, which is their allocated area. What is also permitted under the new order, as with the old, is that the supplier can prevent an exclusive distributor from making active sales to an area or group that's either been exclusively allocated to 1 or more distributors or has been reserved to the supplier. Even if the supplier itself isn't active in that area, the supplier can reserve an area. So that's going to be, for me, when I decide to actually move into that area. On that basis, you cannot sell actively into that area. What we see under the order is a development of this theme whereby it's possible for the supplier to prevent the exclusive distributor's customers from making active sales into these areas or customer groups. And again, that has been positioned to seek to strengthen the protections around exclusive distribution as a model. So you don't have a situation where the exclusive distributor can't make sales actively, but its customers can circumvent that by buying and then selling themselves actively into an area. So that exists as an additional nuance. And just to pick that up in the context of Territory 2. So here we're thinking about Newport in Wales. This has been exclusively allocated to 1 distributor. The distributors in Bristol, they cannot make active sales into Newport because that has been allocated exclusively to somebody else. So their Welsh language website, that's off the table. They can't be doing that because that'd be active selling. What they can do though is make passive sales into Newport. So they invest in general advertising, and that happens to reach customers in Bristol and also customers in Newport. That would be passive selling. That would not be an issue in the context of this model. And we have the same principle applying to the distributor in Newport vis-a-vis Bristol. So again, the distributor in Newport cannot make active sales into Bristol. That has been exclusively allocated, albeit to a number of distributors rather than to 1. However, if we think about Territory 3, this is Bath in England, this hasn't been exclusively allocated to any distributors, and it's not been reserved by the supplier for itself. So on this basis, the distributors in Bristol and Newport, they can make active sales into Bath. So if they want to, they can actually engage in some really quite targeted online search engine advertising to really look for customers within Bath who'd be interested. They can also make passive sales into Bath, whereby they make, as I say, general advertisements that also reach consumers, customers within that particular area. Another development in the context of the new order is there's now greater clarity about whether supplier operates exclusive and selective distribution models in different areas. So what the supplier can do in this context, if a supplier has these different models in operation within the UK, it can prevent an exclusive distributor and its customers from making active or passive sales to any unauthorized resellers who are located where the selective distribution network operates. So you have that protection being afforded. It's not possible for an unauthorized reseller who's located in that distribution network to reach out to an exclusive distributor and passively purchase from them goods that can then be resold to undermine the selective distribution network. However, it would still be possible for that exclusive distributor to make active and passive sales into the area covered by the network. So you don't have complete protection there. You have protection from sales to unauthorized resellers undermining the network, but the selective distribution network can still be the subject of both active and passive selling by an exclusive distributor in the UK. A really interesting feature of the new order, and I think this is where the new order in the UK, I think, goes some way to really open up possible new models, possible new approaches to channels, is that it allows the combination of exclusive and selective distribution in the same area of the UK at different levels of the supply chain. And this is something that the EU block exemption never permitted previously, doesn't permit now. This is a feature of the UK regime. So what this envisages is, at the wholesale level, you would have an exclusive distribution model, whereby you have perhaps different wholesalers being allocated certain territories, and within those they're protected from active selling into those territories. And at the retail level, you have a selective distribution model in operation. So as I say, this is more permissive than what we had previously in the UK and what is now in place in the EU. But I do think that despite these options being on the table, I think the implications of them would need to be carefully considered. I think it's quite tempting where you have new things being put forward to businesses for people to perhaps want to really dig into those. But I think with all of these, if you are thinking about perhaps replacing or developing existing networks, it's a case of really sitting down and working through, what would this all mean in practice? Because for a lot of these different areas, we have points that perhaps haven't been tested so far, and they will need careful thought before implementation. Moving on then to cover some points on selective distribution. In this context, as I mentioned previously, it is possible for a supplier to prevent a distributor and its customers from making active or passive sales to unauthorized resellers that are located where the network operates. And that's almost the quid pro quo of selective distribution. To be admitted to the network, you have to agree as a distributor, you're not going to make any sales to unauthorized third parties that are then going to undermine the brand, the products, the reputation, effectively your own investments in being a member of the network. In addition, we have the possibility under the new order of preventing selective distributors from making active sales into areas or groups that have been reserved to the supplier or allocated to distributors. So again, we now have fully embedded in the order the notion of having exclusive distribution and selective distribution in different areas in the UK, and you can require your selective distributors to respect your exclusive network. They can still make passive sales into the exclusively allocated territories, but they cannot actively sell into those areas. So that is really a key framework within the order, this possibility of having both existing and conjunction. And as we are all familiar with, and as is confirmed by the order, where we have selective distribution, those appointed distributors, they must be able to make active and passive sales, firstly to end users. The network is operating at a retail level, and also to other distributors who've been appointed to the network. They must always be free to make active and passive sales, and the new order in the UK retains that status quo that is unchanged by what we have. What we do have, though, as a slight curiosity in the context of the new order, is a situation where neither exclusive nor selective distribution is considered. And in this context, where a supplier is selling to a distributor who isn't part of an exclusive distribution model and then not a selective distributor, that supplier can prevent the distributor and its customers from making active sales to preserve the exclusive appointed network. So that exists, the possibility again of protecting active selling. Passive sales will still be permitted by the distributor, but it is possible to put in place restrictions to preserve the exclusive network. And also the distributor who is neither exclusive nor selective, they can be prevented from making active or passive sales again to unauthorized resellers that are located where the selective distribution network operates. Again, the distributor itself could make active or passive sales into the selective distribution area, but they cannot make sales to unauthorized resellers who are then potentially going to harm the brand, harm the value of the products in question. That's an interesting development that we see within the new order. And as a result, we have the possibility of at least 3 different models coexisting in the UK. And we touched on exclusive, selective, and neither exclusive nor selective. So the new order is really seeking to set out a range of different options here that businesses may then wish to explore. But as I mentioned previously, I think that the benefits of these different models and how they interact with each other, they really will require very careful consideration as we plot our new course through this landscape. Another area of, I think, evolution, I think in some respects, this is perhaps we've seen more changes than in others, is the treatment of online and offline sales. So what the new order makes really clear is that it is possible for certain restrictions to benefit from exemption under the order. And I just pick out a few of these here. So as a starting point, and again, this is what we had under the previous regime, it is possible to require a distributor in any network form to have a physical store in a specific location. So that's capable of exemption. It is possible for a supplier to charge a distributor different prices depending upon whether the products are to be resold online or offline. Now, in the old regime, that was a hardcore restriction. So that was something that would lose the benefit of the block exemption. In the new order, given the development, the evolution, the explosion we have had of e-commerce, it's now quite clear to competition authorities that online is a separate channel in its own right, and therefore there can be good reasons why a distributor should pay different prices depending upon the channel they're making sales via. So that exists as something that's possible, benefiting from exemption under the order. Equally, imposing quality standards on a distributor, and that would include exclusive distributors, and using different quality standards for online and offline sales. Now that latter part, again, under the old regime, that would have been a hardcore restriction because the intention was that you had effectively equivalence of standards being used between the online and the offline worlds. Once you decouple those channels and you acknowledge that actually online is potentially reaching a very, very different audience to a brick and mortar store, then having different quality standards starts to make a lot more sense, and it starts to be something that actually could be very pro-competitive in terms of driving sales via those online channels, reaching new audiences, potentially with new offerings, new investment, new products, etc. So this idea of having different quality standards for online and offline, that is something that would be capable of exemption in certain circumstances. It is also possible to restrict a distributor's use of digital comparison tools, provided their use is not prevented. So it would be possible, for example, to impose certain quality standards, perhaps to protect the look and feel of a particular product or the positioning of a brand. You could then use those standards to shape how a distributor would use digital comparison tools such as price comparison sites, provided that the use of those sites would not be prevented. And it's also possible to impose direct or indirect bans on the use of marketplaces. I think the big kind of caveat wrap around all of this is all these things are possible and capable of exemption, provided that distributors are not prevented from effectively using the internet to make active or passive sales as they're permitted to do so. I think, for example, if we think about price comparison websites, if it was the case that a supplier was saying to its distributors, you know, okay, outright ban, you cannot use price comparison websites. None of our products will ever appear on a price comparison website. That's the kind of thing that I think would very likely be seen by a competition authority as preventing the effective use of the internet, because consumers would tend to use things like price comparison websites to try and find the best available deal. And that's the sort of thing which I think could then find the benefit of the block exemption being lost in those circumstances if that was categorized as a hardcore restriction. So I think all these things are possible, but we just need to have in mind that there's this catch-all about you can do it provided that that doesn't then prevent the effective use of the internet in those circumstances. There are a couple of what I call hot topics that I just want to cover in the remaining time that we have. And the first is in relation to online marketplaces. And this is an issue where for a number of years, following the judgment of the European Court of Justice in Coty and subsequent guidance from the Commission, we have had a number of questions as practitioners, as businesses, about what can happen in terms of the use of online marketplaces. When we think about online marketplaces, the new order in the UK is quite clear what it thinks an online marketplace is. It thinks of this as being a platform that does something which is connecting resellers with customers. And the reason it does that is to enable direct purchases. So to enable that connection to achieve a direct purchase, there's an acknowledgement that suppliers may want to restrict distributors' activities in relation to online marketplaces. And what we see within the new order in the UK is that it is possible to have exemptions for restrictions. And that would cover things like quality standards, whereby you perhaps limit the use of your distributors' availability of these types of marketplaces. You impose quality standards, maybe one or two can still be used, or it could go so far as to say there's been an outright ban on the use of online marketplaces. What we see from the new order and the accompanying guidance is that the exemption would be available subject to other conditions being satisfied. Supplier could ban a distributor using online marketplaces. They could just say none of our distributors are to use them, and that would be capable of benefiting from exemption. Implicitly, we also glean from the guidance that exemptions should also be available if the supplier bans some distributors from using online marketplaces, but permits others to do so. And there is within at least the UK case law a very clear concept that within such distribution models, you don't, for example, have to treat all distributors equally. You can have different standards being applied to different distributors for different reasons. So following that through, implicitly, it would be capable of exemption if a supplier prevents some distributors using online marketplaces, but permits others to do so. Similarly, from the guidance we glean, that the supplier may also decide it's going to use online marketplaces itself, but it's going to ban its distributors from doing so. And from what we have so far, that again would be capable of benefiting from block exemption under the order where party shares are below 30%, etc. I think with all of this, we need to remember the wraparound. And the wraparound is these things will be possible provided the distributors are not then prevented from effectively using the internet to make sales. And I think that is where we have the order, we have the draft guidance, we have this space being left for arguments to be made. And I think where people are thinking about online marketplace restrictions, it is worth just bearing in mind that there is room to maneuver there for parties who are perhaps dissatisfied with decisions that are made. So if you are implementing something that could be viewed as being discriminatory vis-a-vis certain distributors, then it may be possible, given the current language and the lack of any sort of case law or decisional practice, for certain distributors to mount a challenge to that based upon competitional arguments. So, well, actually, this restriction, it does prevent us from effectively using the internet, and therefore it shouldn't be permitted under the block exemption. So I think this is an area where, although we have now a clearer position, to my mind, this is not settled. I think we will see further debates going on around the use of online marketplaces and how this can be positioned and structured. I think another area that is worth touching upon is the issue of information exchange. And this is an area which has been a reasonably hot topic, as we've seen in recent years. I think more brand owners moving into the retail level themselves. There's been more head-to-head competition between brand owners and their established distribution networks. So what is clear is where you do have this competition at a retail level, and you do have exchange of information between competing suppliers and their distributors, there is an acknowledgement by competition authorities that actually information does need to be exchanged. Yes, they are competing at retail level, but nevertheless, there does need to be an exchange of information between those competitors, not least because the distributor is selling suppliers' products. They need to think about how they maximize sales. That's both in the supplier's interest, the distributor's interest, and ultimately, you'd hope the consumer's interest. So there does need to be an exchange of information between the parties. What we have in the guidance that accompanies the new order is we have a categorization of different types of information that should generally benefit from exemption under the order. So I've just picked out a few of them here. So where we have exchanges of information that relate to marketing, for example, so information on perhaps new contract products or new promotional campaigns for those products, and that should be permitted in the circumstances. In the context of customer-related information, where we're thinking here, and I think this is important, so aggregated information about customer purchases, information generally around customer preferences and feedback. Again, you can see why that is valuable information in the context of improving the distribution of products, and therefore it's appropriate for that to be shared between supplier and their competing distributor. And certain performance-related information. And again, we're thinking here, given the sensitivity, aggregated information, and that could cover things like the marketing and sales activities of other distributors. So at an aggregated level, where you're perhaps using this for benchmarking purposes, that would be something that would generally benefit from exemption under the new order in the UK. Where we are thinking about things that would be unlikely to benefit, although a fact-specific assessment is required, the general categories would include things like future retail pricing information. I think you could argue positions and carve-outs there about intended promotions that are going to be consumer-facing, low price, limited time period, but otherwise more general sharing of future pricing information. You can see why that would be a cause for concern. And also when we're thinking about customer-specific information, where this is disaggregated, so we get into the granular information about the parties' sales to individual customers. Again, given that competitive dynamic between supplier and distributor at the retail level, it's clear why that could give rise to concerns and therefore be unlikely to benefit from exemption under the order. If it is the case that aspects of the exchange wouldn't benefit from exemption, and there's a question there about whether or not individual exemption may be available, but I think more practically, and this is where I think a lot of businesses would instinctively go to is, okay, firstly, do we need the information in its current format? Can we revise, can we restructure? So we pull this back from where it is and we get ourselves comfortable that what we're operating with day to day is actually something that by aggregating, for example, we can get ourselves within that safer space of exemption under the order. So my suspicion is that is where, if companies aren't already, that is where we will perhaps see a revision of some of that information exchange and a restructuring of some of those formats. So to summarise, I think then what we see under the order and the guidance is, as I mentioned before, we have a basis here for the first time stated really clearly of coexistence of these updated core models in the UK. We have a more permissive approach to differing treatments of online and offline sales, which I think could give rise to lots of opportunities for businesses. We have greater clarity regarding the permissible restrictions upon distributors' use of online marketplaces. As I said, I don't think the debate is settled, but we do have a direction of travel and greater clarity in that regard. With greater certainty about permissible exchange of information, where we have competing suppliers and distributors at the retail level. I think it is worth flagging there that all these restrictions should be considered on a case-by-case basis, even more so when we're thinking about direct and indirect restrictions in the online world. And another point that, again, we need to keep an eye on now, but also have an eye on in the future, is what is the approach going to be where you have a business which requires arrangements to be implemented both within the UK and also in the EU. So would you lean towards having one agreement that's compatible with both, taking the most restrictive as a baseline, or would you have separate agreements for each? And that's going to be a commercial decision based upon where the most value is going to be. And if there's more value in having a bespoke UK style agreement because of the importance of that particular space, then obviously that's where businesses will go. But I think it's worth thinking about now, so that if you do need to have aspects that are tailored, that thinking has been done in advance rather than kind of 11th hour in the context of a project. A couple of points then before we pick up some of the questions that we've had through. I think one point to note in the context of the new regime is a new power for the CMA. So the CMA is empowered by the new UK order to request information from parties. And persons are required to supply information that the CMA requests in relation to agreements, and they must do so within 10 working days of receiving written notice, or, and I think in practice this is what we will see, a longer period as may be agreed with the CMA. If a party fails to comply without reasonable excuse, then the CMA is able to cancel the benefit or the block exemption order in relation to any agreement to which the request relates. So there is that, I suppose, the stick approach of, we'd like you to provide this, and if you don't provide it, we could ultimately cancel the benefit of the block exemption order. In reality, that may not affect businesses, particularly people may be quite comfortable that actually if the order was cancelled, we're okay, thanks very much, because we can still fall back on the possibility of individual exemption under Section 9. But I think reputationally there'll be an issue there to make sure that parties are seen to be cooperative with the authority. And there's a question here about, is this something which the CMA starts to use on quite a regular basis, or is this something which is, yes, it exists in theory, but actually in practice the CMA doesn't choose to invoke this power. And then to wrap up in terms of the session itself, as we have the sun setting on the old regime and rising the next morning on the new, we have the transitional provision which is captured within the order. And what this does is effectively gives comfort for businesses that if you had an arrangement that was entered into before the 1st of June, which is when obviously the new order came into force, and it didn't benefit from exemption at that time, but immediately prior to the order entering into force, the agreement did benefit from exemption under the old regime that was in place, then what you have is a period of 1 year within which that arrangement will be treated as benefiting from the new order. So in effect, you have a year to align yourself with the new regime and to make sure that you're comfortable and confident you are compliant with the relevant provisions in those circumstances. So, mindful of time, I think that does leave us a few minutes for questions. And let me just pull things up. Okay, so question here about resale price maintenance in terms of the new regime? Is it more permissive in relation to resale price maintenance? So, as I said, I wasn't talking about issues around resale price maintenance, but happy to pick this up. I think just to give some colour to that. So, resale price maintenance, I think there was perhaps an expectation that with a new UK regime, there may be some more flexibility around the use of resale price maintenance in certain circumstances. Where we've landed is resale price maintenance is still very much positioned as a hardcore restriction. There is an acknowledgement that resale price maintenance in certain circumstances can give rise to certain efficiencies, but I'm afraid that what we have is the efficiencies have in effect been reprised from the earlier guidance around verticals. So we're thinking there about things like a low-cost short-term promotional offer where a fixed price is set, or the launch of a new product where a fixed price is set to enable investment, return on investment to support the launch of a product. But we haven't seen any further development of thinking around possible efficiency. So that kind of sits almost as it did under the old regime. We have a question here about market shares. So what happens if you enter into the agreement and market shares at the time are below 30%, but then they go above 30% afterwards? That's a really good question. I should have made clear that in terms of 30%, that is not something whereby you enter the agreement at 30% and therefore you will always benefit from block exemption. This is something, as we all know within markets, shares can and do fluctuate. If parties find that their share does go above 30%, there are certain grace periods available. So if their share goes above 35%, for example, they would then have a grace period of, I think, 12 months within which the block exemption order would continue to apply. And once that expires, if they are still in a position whereby they are outside the market share threshold, it would then be a case of thinking about the possibility of individual exemption under Section 9 of the Competition Act. And again, going through those cumulative criteria with the assistance of things like the guidance that accompanies the new order to self-assess in that context to ensure that you are where you think you are in terms of compliance. But I think it's a really good point in terms of, I think particularly some of these markets where we see big changes around participants, that can obviously lead to shifts in shares. It is for businesses just to keep self-assessing to make sure that they think their agreements are benefiting from the exemption insofar as it is available. I'm mindful of time, but I think we may have time for just perhaps one more question. Question here about, okay, so this goes to the point about passing on obligations to customers. And as I said, this is a new parameter we see under the UK order. It's quite thin in terms of how this would work in practice. So I think the notion of pass on is that either the distributor's customers will enter into agreement with the supplier, or the distributor will enter into an agreement with its own customers to ensure that these obligations around sales restrictions, for example, are then honoured by the customers in question. I think in practice that may work really, really well in certain sectors, and it may be something that is well respected, self-policing, people got no issues signing up to it. I think in other sectors it could be really challenging to get customers to agree to that. It could hold up transactions, it could prompt more questions, more issues. So I think what that translates into in terms of our real world commerce, I think is going to vary sector by sector. I think going to the theme of giving different options to businesses, it exists as an option. So it's something that businesses can now seek to do, which they didn't have the option to do previously. I think in that respect, it is a welcome development. The question then is, how do you go about implementing that? And I think that is as part of all of our Brave New World with the new order, something that we will, with trial and error, I think, get to a landing point on. I'm mindful of time. I will close the session now. If I haven't had a chance to respond to questions, I will pick those up after the session. In the meantime, thank you very much for joining. I hope that was of interest, and look forward to speaking with you and meeting with you in person at future ThinkHouse events.